Welcome to the Ultimate Property Management Virtual Masterclass Part 2, brought to you by Real Estate Investor. Today's masterclass is officially sponsored by We Connect You, developers of intelligent property management software to enable you to scale and deliver more value to your clients. Real Estate Investor and We Connect You really have a common goal, and that is to fast track property or prop tech in the property management space. And we want people to adopt it into their businesses. More importantly, today we'll actually provide you with the education, the direction, the tools on how to build a scalable property management business, and most importantly, how to effectively manage your prime property assets. This is critical. Such an important function for an investor and also for the property manager on the other side. Many detractors say that property managers do lack innovation, and if they don't embrace PropTech, that will certainly die. And there has been an influx of several tech companies disrupting the property management space recently that promises to transform the old traditional real estate industry as we know it. His topic for today is the new Rental Housing Act, how you need to prepare yourself. And so please welcome Marlon Shevelew, and he told us that he's got some scare tactics for us today. So Marlon, it's over to you. It's wonderful having you on the masterclass.
Thanks, Neil. Great to be here, and very thrilled to have the opportunity to speak to these wonderful delegates. So I think just before we begin, I think what's important to realize is that the Rental Housing Act has, just to go back to my original slide, the Rental Housing Act is dated 1999. And the amendment to that act is 2007. And of course, we've got the 2014 amendment, which is coming in. I think it's very, very important to realize that at this point in time, we're looking at the date of October as being the date whereupon the new act will come into being. And of course, that will be the time period in which we will have a situation where there'll be a grace period for that to start like move into I suppose, into a position where it actually starts filtering through the entire rental industry. What I just want to point out as a precursor, just like we had the Consumer Protection Act come out, we had regulations, and those regulations need to be read with the Consumer Protection Act. Not dissimilar to this, the Rental Housing Act, which is going to be amended, has to be read with the regulations. And as you'll see from these slide notes, which we're going to go through quite quickly, but which will be made available, you will see that those regulations are out for public comment. So there are changes potentially that are going to come in. What I'm going to be talking about today is just a few points from the new Rental Housing Act, which is going to come out in October, with some of the regulations, point out some of the problems I have, some of the idiosyncrasies, but also to mention that what I've given We Connect You and Real Estate Investor is a copy of all the information that I received when I attended the public participation process. And that's when I attended, and we actually met with the draftsman of these regulations. So you can see exactly what is coming in. That's quite a substantial pack if you really want to read all about it. So without further ado, thank you once again for this opportunity. You'll see some coloring on my slides, which is important because there's the Rental Housing Act of 99, there's the amendment of 2007, which was brought in 2008, and there's the 2014 amendment, which as of 2021 has still not come in. So it's taken 7 years just to get the act to a point where it might come in and should come in October 2021, and the regulations which are out for public comment, which is going to be read together with the new act, which means, in short, ladies and gentlemen, that the provincial regulations, Western Cape, Gauteng, KwaZulu-Natal, etc., are going to be removed. There's also a national set of 2008 regulations, which was drafted. It went nowhere. That's also going to be removed from the table. So ultimately, what we're going to have come 2022 will be a brand new Rental Housing Act, 99 but amended to 2014, and a national set of regulations, which is great news. A couple of things you need to be aware of. There's quite a few definitions that have been brought in to the new legislation. The first one is habitability. The importance of habitability and maintenance cannot be underestimated. Please be aware of that, because now suddenly there's an obligation on behalf of the landlord to provide adequate space, make sure that there's no threats to health, make sure you look after the physical safety of the tenant, make sure it's a structurally sound building. And equally to that, there's a duty to maintain that dwelling along those lines. in short, what that means is if a tenant can prove that, for example, they haven't been provided with adequate space, or they don't feel physically safe in the dwelling that they're renting from you as a landlord, they could potentially have a ground to cancel the lease or to not pay rental. How wide is this? We don't know. We're going to wait and see until the act actually comes in and what happens in my arena as a specialist litigating attorney. Moving on to what the aim of this act is, and I think if you just read from the beginning of the 2014 amendment, you will see that it's very tenant-centric. It's very geared towards protecting the tenant. There are some good things that have come in, as I will elaborate upon, but as a rental agent, as a rental asset manager, as a landlord, as an investor, invariably, you need to understand that the act is leaning more towards the tenant. It's leaning more towards access to housing, poor and vulnerable people, people who have a right, and rightly so, to have access to health, to physical safety, to basic services. And that's why there's been quite a fundamental change in, I suppose, the personality of the Rental Housing Act. For example, you will now see that instead of Section 5.3 of the Rental Housing Act, which talked about the rights and obligations of tenants and landlords, it's a lovely section, it's now been changed to show that it is now the actual duties, the actual obligations. So whereas we had relations between landlords and tenants, we now have rights and obligations. What the Rental Housing Amendment Act has done is it's actually separated the rental obligations and duties of tenants and rent obligations and duties of landlords. It's pretty much put it in a nice formulaic way, so you can't miss out on what those obligations and duties are. A lot of them are similar, but there are quite a few changes, and some wording has actually created quite a problem for me. I originally did a webinar on this in 2019, anticipating it to come out soon. It didn't come out as soon as I wanted, but now that I've seen the regulations, which have only been made available as of April this year, I've actually seen what problems we foresee, simply because we need those regulations to be read with the Rental Housing Act. And those regulations have some very curious content, which I will take you through. What I will mention right now is that the regulations, which we've now been educated on at the public participation process, is very procedural in nature. So it talks a lot about the procedures at the tribunal and not so much the substantive aspects, which is also problematic because we need those regulations to truly understand what the amendments to the Rental Housing Act actually mean. So moving on, a stupid example maybe, but I don't know, you tell me. In the current Rental Housing Act, it says the tenant has a right to receive, or the current Rental Amendment Act, I should say, the tenant has a right to receive a written receipt. In the Rental Housing Act of 1999, which currently is what we are using, it says the landlord must furnish a written receipt. So just a change of wording there makes it a bit more obligatory for a landlord. There are some definitions that have come in which look fantastic, but unfortunately, the new Rental Housing Amendment Act has fallen flat. So you're going to see I'm basically going to be vacillating between new sections which help, new sections which don't help at all. Section 4A5, this is a new section that's come in to the Rental Housing Amendment Act, pretty much says everyone has a right to privacy, and if you want to do an inspection, ultimately the inspection must be done in such a way that it's reasonable notice and that you're allowed to do an inspection of the property. But did you know there is nothing in the Rental Housing Act, in the 2007 amendment, or even the 2014 amendment, or the regulations to the 2014 amendment, which actually give you an answer as to what to do if you're not allowed access to the property. That's the bottom line. You have to go to court for a high court interdict to get that. So it falls flat. It hasn't addressed that particular issue. Then you get what we call some contradictions. And I do apologize for going so quickly. 20 minutes is all I've got. Normally it takes me 20 minutes just to say hello. Section 4A8 talks about the fact, and it's a little bit contradictory, and maybe you can read it differently. It says that a tenant is liable for rental and all costs that are agreed upon in the lease. And if those costs are not in the lease agreement, that landlord should be able to show what factual expenditure there was in order for the tenant to pay that. But a lot further on in the Act, it says, any charges that are not reflected in the lease are not able to be claimed. So that is a bit of a contradiction. What exactly is a landlord allowed to charge a tenant? Is it in the lease? Is it not in the lease? What is factual expenditure? What if a landlord wants to do some architectural renovations to his property and puts that in the lease agreement? Is the tenant then liable? Surely not. That's open for debate. Another one is, which is being concretized now, which is very important, is that a tenant can't sublet a dwelling without the consent of the landlord, which of course can't be unreasonably withheld. It's not a new section as such, but it's amplified upon, and it's basically saying a tenant is allowed to sublet. Absolutely, but it can't be subletting in a way that abuses the landlord's property. So it's not looking to negate the landlord's rights, but the answer is the tenant must be allowed to sublet the property. He may need to supplement his income to pay the rental. And of course, that brings in the whole realm of a sublessee or a subtenant, which of course brings in the whole definition of what a user is in terms of the Consumer Protection Act. Because any subtenant is deemed to be a consumer of a supplier, which is a landlord in terms of the Consumer Protection Act. It's going to be particularly interesting to see how the Consumer Protection Act reads with the new amended Rental Housing Act. Moving on, another very, very strange definition. Currently, you would all know from the Rental Housing Act of 1999, unamended as it is, basically says that a landlord and a tenant must organize an outgoing inspection at a mutually convenient time. It's got to be done by consent. The wording now strangely says the landlord must organize the outgoing inspection, not the landlord and the tenant. Places an obligation on the landlord. What happens if the tenant doesn't consent? What happens if they don't agree? What happens to the outgoing inspection? The outgoing inspection, you can't have an incoming inspection married up with the outgoing, and therefore you've got an issue with the deposit. Let's ignore the fact that if a deposit is not paid back at the end of the lease agreement, as you'll see later, that is a criminal offense in terms of the new 2014 Amendment Act. And yet we've got clauses and sections, clauses in the pro forma lease and sections in the new Amendment Act, which are potentially contradictory and challenging. For example, section 4B9A, this is all the new 2014 Amendment Act. Whatever it says 2014 Act, that's the new amendment to the Act, basically said a landlord is entitled to be paid regularly with regard to the rental and any charges that are payable in terms of the lease. But what if those charges are not payable? What are those charges? What are they charges unrelated to the rental? The good thing, and probably one of the best things that do come out of the Act, because it's not all bad, ladies and gentlemen, and I don't mean to be fatalistic, but the fact of the matter is, it does definitely concretize the fact, and I've always mentioned this throughout my webinars, there is no law in South Africa that prescribes how much time you need to give a tenant after you've cancelled their lease to vacate. So you can tell the tenant to leave the next day if you've cancelled the lease, and if you cancel the lease and they remain on in the property, they're an unlawful occupier and they must leave. That is concretized in the new Act. Also, what is becoming very, very interesting now is that whereas it wasn't always a requirement for a lease to be put in writing, in fact, an oral lease is absolutely fine in our law, except of course if you don't understand the terms and conditions of the agreement, in which event it comes down to credibility of the landlord and the tenant if it goes to court. Now, it must be reduced to writing. But it gets even more interesting when we're talking about it must be reduced to writing, because our minister, in terms of the Act, has basically provided that there must be a pro forma lease in 11 official languages, which must be used as a guideline by tenants and landlords. Now, what's very interesting is that the pro forma lease has actually been prepared. It's a guideline, but it has been prepared, and that pro forma lease is attached as a schedule to the new regulations and will be available in the pack of documents that We Connect You and REI, Real Estate Investor, has already. We got that pack when we attended the public participation process. Now, what if the lease is not in writing? What if it's not understood by the tenant? What if it's not translated into the official language? What happens in terms of Section 22 of the Consumer Protection Act, which talks about the importance of agreements being in plain language? Well, I don't know if you know this, but if you don't put a lease in writing, you could potentially be arrested and going to jail for not complying with the 2014 Amendment Act. And it gets a little bit more interesting, not to again be so pessimistic, but we've got a pro forma lease. We've got it in plain language, purportedly, but we've only got it in English. We don't know what's going to happen when the other pro forma leases are translated into 10 other official languages. It's going to be interesting. But what's very, very interesting is that this pro forma lease, which has been prepared by the draftsman of the regulations who presented the public participation process at the Cullinan Natal recently, which I was on the invitation of the Rental Housing Tribunal, was very privileged to attend. The lease doesn't talk about ingoing or outgoing inspections. It doesn't talk about interest, which is accrued on a deposit. It mentions nothing with regard to the 20 business days. It simply says period of time to pay, otherwise we can cancel. And it also calls them lessors and lessees. So what's happening to the terminology landlord and tenants? Is that still allowed? Well, it remains to be seen. The bottom line is that there are going to be a lot of comments coming through on those regulations, on the Act itself. That's why we have a public participation process, where investors, property brokers, rental asset managers can voice their views and let the draftsman know what makes sense or what is nonsensical. Very interesting as well, two particular aspects of Clause 8 of the pro forma lease, which has been prepared, is, amazingly, is that there is now potentially a right for you to take the deposit during the currency of the lease, use it to fix up damages, and then call upon the tenant to top up that depleted deposit. That currently is not allowed. It's not provided for in the Rental Housing Act, and it's going to be very, very interesting to see how that plays out, because that actually completely contradicts and conflicts with the deposit that's put in an interest-bearing account and accrues interest and can only be touched at the end of the lease period in terms of the current Rental Housing Act. So how that's going to work out, it remains to be seen. And also, it just mentions briefly in the lease agreement that the deposit must be paid back at the end of the lease agreement plus interest. But then again, ignores all the time limits which are currently in place. For example, 7 days, 14 days, or 21 days from date of cancellation, depending on what happens at that outgoing inspection. So it's going to be very interesting. And of course, it remains to be seen how all these nuances are dealt with in different languages in terms of the pro formas that are prepared. Moving on. What is very scary, and I don't mean to scare you, but I suppose probably rather be scared and be mindful than put your head in the sand. We've had criminal offences throughout from 1999 to 2007 up until now. The criminal offences are quite self-explanatory in terms of the current Rental Housing Act. The 2007 amendment spoke about locking people out or turning off the utilities, meaning you can go to jail. But incredibly, the new criminal offences talk about if you don't repay a deposit, you can go to jail. If you don't give a habitable dwelling, you can go to jail. If you don't put the lease in writing, you can go to jail. That is what they're saying. It's printed in the Rental Housing Amendment Act. These are criminal offences. But what if you don't want to pay back the deposit because there's a dispute? Do you still go to jail? What is habitable? What is adequate space? What is physical safety? What is maintaining a dwelling in a habitable fashion? What does this all mean? Is that still going to be a criminal offence? And what if you don't put the lease in writing? What if you don't understand the 11 official languages and you can't put it in the language of the choice of the tenant? Is that a criminal offence? Are you then going to go to jail? Interesting. The best section of all, which as we bring this to a close, is the best section of all is the section 17, where to section 17A. What this is basically saying is if you as a rental agent or a landlord go to the tribunal and you lose, currently if you lose, you can only take the presiding officers and the matter on review, which is purely a procedural aspect. Now, with the 2014 Amendment Act coming in, you can actually appeal a decision if you're not happy, and it's an appeal internally. If we have had to ever deal with an unhappy landlord in a rental tribunal, our only procedure as attorneys who specialize in rental property law was to approach the High Court to review the procedural aspects of the decision. Now you can challenge the actual merits of the matter internally in the same tribunal before an adjudicator without having to spend money on an advocate or even an attorney in the High Court. That is absolutely brilliant, and that brings home the access to justice, which I really think is a phenomenal aspect of this particular amendment. As we bring this to a close, we're going to deal very quickly with the regulations, and pretty much what I want to tell you is that a lot of the regulations are very procedural. They talk about the duties of the tribunal, how many members, etc. So we're not going to focus on that, but it doesn't specialize in or specifically deal with the substantive issues, which we really need to have an understanding of. So just to shoot through it very quickly, it's all in gray because I'm not going to deal with it right here. But if you read through it very carefully, and if you look at the pack, you'll see the actual regulations are covered in the pack of documents that are provided. The bottom line is that the one I want to draw your attention to is the mediation session. Now, if you're ever called to the tribunal and you have to have a mediation because there's a dispute between the landlord and the tenant, that mediation is supposed to be off the record. And what it says quite contradictory is that the mediation is supposed to be voluntary, but yet you can be subpoenaed. So that's really not voluntary at all. Secondly, if you go to mediation and you have your say, that should be off the record. That's the intention. So you don't compromise yourself with information that you don't really want to come before a hearing. But yet, even though it is off the record, the regulations also say that if you don't come to an agreement, the mediator must report a summary of that evidence for purposes of the actual hearing. So that completely negates any alleged without prejudice meetings that you have. It's all very legal, but I'm just pointing out the idiosyncrasies in this. And finally, as we move on to the substantive regulations, some interesting information is also coming out, and that is the following. There can't be any more, in terms of the current 2014 amendment, which is coming in, there can't be penalties for late payment of rental, other than interest. That's pretty much along the lines of the Gazetted unfair practice regulations. That's very interesting. You can't put anything in your lease agreement that denies any liability on behalf of a landlord or an agent or a tenant. So they must always comply with the law, pretty simple. You can't limit their rights in terms of this new amendment. And of course, if they want to form an association, like a group of people, you can't stop that either. It's a little bit vague, but there's some good aspects coming out of that as well. And then, of course, the obligations, which are continually important for landlords. Maintain and prepare the common property, maintain systems, provide and maintain containers for refuse, do repairs, tenants must use the premises which they are let, dispose of refuse, maintain the property, all pretty simple stuff. Don't damage the property, return it in the same condition in which it was received, fair wear and tear excluded. Ironically, the terminology in the current Rental Housing Act of 1999 is fair wear and tear accepted, not excluded. I don't know if anything turns upon that. And of course, make sure that the premises are habitable, livable, space, physical health, and there is a reciprocal duty on landlords and tenants to respect each other. If there's a swimming pool, maintain a swimming pool. If there are house rules, maintain the house rules, make sure the tenants understand that, and those house rules must of course be attached to the lease agreement. And ultimately, my only hope to bring this webinar to a close, and I hope I haven't been too verbose and too fast, is that ultimately we want a situation where there's a national set of unfair practice regulations which are finalized, fair, and truly reflective of the state of South Africa at the moment. And what I will end off with is that now a landlord will be called a landowner. And that's always intrigued me because, as you know, you don't have to be a landowner to be a landlord. I can be a landlord, I can lease to you as a tenant, and you as a tenant can sublease to another tenant, a subtenant. That would make you the landlord of your own tenant, but not an owner of the property. And that, Neil, brings my webinar to an end. I have no idea how long it was, but I hope it was enough to scare the people and to make them realize that residential rental property law is not to be scoffed at. It's a real area of law that needs to be understood.
Excellent. Thank you, Marlon. I think that was great insight.